I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for these lessons on state public record laws and the Federal Freedom of Information Act. This is the fourth round of lessons that all build on one another. First, we discussed the law itself, what it covers and how it can be used. Then, we invited a local journalist to share 3 specific requests they made and the stories that resulted. Our previous round of lessons focused on the appeals process, what to do when your request is denied. And now we again have a local journalist to share their experience using the appeals process to obtain records for their reporting. Links to all videos, as well as other valuable information, can be found at nefac.org/FOI guide. This round of lessons is brought to you by NEFAC with support from the Rhode Island Foundation, the SPJ Foundation, MuckRock, SPJ New England, and the New England Society of News Editors. Thank you again for joining us. Now, here's NEFAC's Emily Sweeney to introduce you to your instructor.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you all for joining us for this webinar, which is part of our ongoing series on public records laws. This session is going to focus on how a newsroom used the public records appeals process to fight for information in Massachusetts. And with us is Todd Wallack. Todd has been deputy managing editor in the WBUR newsroom since March 2021. And as part of that role, he oversees a team of reporters who cover politics, criminal justice, and general news. And also, I know Todd from his days at the Globe. I know him as a champion of the First Amendment. And also, I don't know anybody who knows like public records laws, so well. I mean, he's one of the experts here. So Todd, thank you so much for joining us today.
Yeah, no, absolutely. I will share my screen and talk a little bit about a particular public records fight that I had that had mixed success. It started when Aaron Hernandez, a former tight end for the New England Patriots, died by suicide. And he has the distinction of, I think, still being the only NFL player to be charged with 3 murders. And obviously really well known and an awful tragedy in New England. One of the things is he was in multiple jails, including the Bristol County House of Correction and Jail, and left a paper trail. Whenever somebody is anywhere, there are records attached to it. So after he died, I put out a records request to a number of agencies, including the Bristol County Sheriff's Office, which operates the jail, for a whole long list of records, including inmate records and video recordings and documents. It was just a broad search. For future reference, I've generally had better success when I've had narrower requests for a specific document or a specific type, but in this case, it was a blast request to a lot of people. And not surprisingly, the Bristol County Sheriff's Office initially turned me down, and they had a long explanation, for instance, about the telephone records and how disclosure of inmate telephone records to the general public is not permitted. Later on, I decided I really wanted the recordings of what he was talking about when he was in jail. And this is a copy of the public records request I made, where it's more narrowly focused just on the recordings. And the heart of the request was, just saying this is a public records request and I'm asking for recordings of telephone calls. A public records request, as you know, doesn't have to follow a preferred format. I tend to use a template that the Secretary of State's office recommends that cites the law. There are actually some studies that have found that if you cite the specific law, you're more likely to get the records. And if you call it the wrong thing, you might be less likely to get the records. So if you call it the Freedom of Information Act, which is a federal law, they might think, this person doesn't know what they're doing. But a request could be one sentence. Please send me X. It doesn't have to be all that complicated. In this case, I knew that the agency had a general policy of not giving out telephone recordings, though. So I did something I normally don't do, which is I went in the initial request, I provided an explanation for why these records are public. Most of the time, I just let everybody assume they're public until they tell me otherwise. But in this case, I knew they were going to make an argument that telephone calls involving inmates are confidential. So I point out all the reasons why there's not an expectation of privacy. He's a public figure. He's convicted of murder. Everybody's told that this is a recorded line. There's an SJC ruling that said prosecutors could use inmate calls against them because they don't have an expectation of privacy. I also included a copy of his death certificate and said, he's dead. He doesn't have any expectation of privacy. And often when you're asking for records of somebody who's deceased, I found it helpful to include a copy of the death certificate that eliminates any question. In this case, I didn't get an immediate response. And so I do what I often have to do with public records requests, which is lots of follow-up. So, hi, I'm just following up on my request. And I got an acknowledgement, should work on it next week, which is great. I put that on my calendar. Next week comes up. I am checking in again. I found the single most important thing with public records requests is just being the squeaky wheel, making lots of noise, being an annoyance. So hopefully they give me records so I will go away and stop bothering them. Unfortunately, I will just need more time. The records person wrote, and I follow up and say, oh, okay, you're saying 2 weeks. So trying to pin them down on a date. I get the auto response, she's already gone vacation. But I put that date down on my calendar anyway. And 2 weeks later, hope you had a restful vacation. I just wanted to check on the status of my request. I'm not going away. And I asked her also about the spam labels at the top. And she said, still hasn't forgotten about me. I'm still just making sure the records can be disclosed. And she indicates that she has some worry about whether they're public. So I go ahead and point out, hey, there are all these reasons why it's public. A lot of these calls have already been in court records, their transcripts. There's that court case that says jail calls are not private, and hope that will help give additional ammunition. And she says, I still need to be sure that the records can be disclosed. And I thank them. It's always helpful to be nice, be cordial. You want a good relationship. People are more likely to give you records if you're nice to them and they don't think you're a jerk. And I didn't hear anything for a while, but in the meantime, my colleagues and I are producing the Spotlight series, Gladiator, on Aaron Hernandez. And we had gotten jail calls in the meantime from another jail in Suffolk County. So we had hundreds of calls from Suffolk, and we didn't want to make too big a fuss and blow the fact that we had these Suffolk calls while fighting for the Bristol calls. So we were a little gentle in our approach until we had this published. Once the series came out, it was also a podcast. I went back because reporters don't forget, and said, I just want to follow up. Now, in this case, I was thinking, I'm going to appeal. I'm not getting anywhere, but the trick with appeals, as you may know, is that you can only appeal the Secretary of State's office if your last correspondence has been within 90 days. Otherwise, it sets the clock again. So I sent a copy of my request and said, I just want to follow up again. I got a response a little over a week later saying, it's still under review. It's been months and months and months and months. And hopefully I'll have an answer soon. At this point, I just decide I'm going to go ahead and appeal. I've been getting the runaround. So I go to the Secretary of State's office, which oversees appeals for public records, and point out that I'm still waiting for a response and they're supposed to respond within 10 business days. And you just, as you know, you can appeal with a copy of your written response, your request, the response, and a brief letter. Mine's just saying they didn't respond. They acknowledged my request. And, funny thing, a week after filing this appeal, they said, oh, we are going to give you the records. And within days, they're producing this CDs. They said, we just need a little bit more time. So I withdraw my request, my appeal. I have been amazed at how often just appealing a public records request and copying the original agency will unlock these records that have been sitting around. A lot of people don't want the hassle of dealing with the Secretary of State's office. They don't want the embarrassment of being ordered to provide records. And so filing an appeal can be really helpful when being nice and being persistent isn't enough. And we wound up producing a story based on hundreds of new calls that we got from Aaron Hernandez's time in Bristol County jail. Now, I will say that we got very different responses from different agencies that we asked for recordings. So Suffolk County, as I mentioned, they provided the records without me having to appeal at all. I did have to wait a little bit of time, but not that much. They were very helpful. Bristol, as you saw, gave me the runaround for months and months and months and months until I appealed, and then they gave me the records. It probably didn't hurt that Gladiator had already come out and they probably already noticed that their friends in Suffolk County Jail had already given out similar recordings. I'm told that often it is helpful to note that other agencies have already given you the same records. Peer pressure works. Agencies don't want to feel like they're the only ones who are giving you a hard time. And it feels like it lets them off the hook a little to know somebody else already stuck their neck out, or maybe everybody else is giving out the records. But I got a very different response from Massachusetts Department of Correction. They blew me off when I made that big records request in 2017. When I narrowed it down in 2018 and just asked for the records, they said, the department again denies your request. Just turn me down cold. So in that case, it was clear they weren't thinking about it. They weren't saying we need more time. They were just denying me. So I filed an appeal. It took several rounds of appeals back and forth, and the supervisor of records kept saying, you haven't shown that these records are not public, and you need to follow the law and either prove that they're not public or provide the records. The agency, even in the face of an order, the agency just kept sending out denials, denial. So at this point, I went back to the Secretary of State's office and they said, we're just going to send it over to the Attorney General's office to enforce this order. So the Secretary of State's office is charged with handling appeals, but the Secretary of State's office doesn't have any power to actually enforce the law itself. It has to rely on the Attorney General's office to actually go to court and enforce the law. So it referred it to the Attorney General. The Attorney General thought about it for about a year and then said, yeah, these records are public. They could be redacted, but at least Mr. Hernandez's side is public. So you need to either release the records or explain why you can't just redact portions of the records. And it's, by the way, it's very rare for the Attorney General to send these types of letters out. So this was really seemed like a helpful letter. Let's see. And sorry. Oh, sorry. I got a response back. Sorry, I am sending you the wrong thing. They denied my request again. And said that they basically couldn't do it. And then the Attorney General said, after a number of months, okay, yeah, that sounds reasonable. The Department of Corrections said it's going to take us hours and hours and hours to redact each phone call to remove all but Aaron Hernandez's voice. It's going to be too expensive, take up months and months and months. And the Attorney General's office said, yeah, that sounds like it's too much. We're not going to require the Department of Correction to do that. They said, well, we encourage you to work with the requester and try to narrow the request and try to work something out, but we're not going to force you to do it. So it just shows the appeals process can be helpful at times, but it won't always result in success, and you can get wildly different responses from different agencies.
Todd, that's eye-opening. I mean, I knew agencies could, give different responses, but it's amazing to see how they responded to the same request. But,
right, and obviously, people have the option of going to court to get the records, filing a lawsuit, and as long as the Secretary of State's office or the Attorney General don't rule against you and don't rule that the records are not public, you're presumed to be entitled to collect your attorney's fees if you successfully sue for records. And consequently, there are a lot of public records attorneys like Peter Caruso Sr. who are raising their hand and offering to represent journalists for free in public records suits if they have a good case.
Julie Cohen is asking, do you ever work with a lawyer to help you through the appeals process? And did your employer provide the attorney?
So I do not use an attorney to file an appeal with the Secretary of State's office. To me, it's really simple. It's a simple process. The Secretary of State's office have their own attorneys who are going to handle it. It's not like a courtroom. I have used attorneys to decide when to go to court ourselves. It's very rare for the Attorney General to actually take on a case and sue an agency, particularly a state agency, particularly the Department of something like the Department of Correction. The Attorney General represents the Department of Correction in court all the time. So it's an awkward place to turn around and sue a state agency. There have been two cases in the history of the Attorney General's office where they've sued agencies. One was they sued 3 district attorneys for not releasing lists of cases they brought. That was in response to a public records case I had made. And the second, more recently, was after a reporter asked for records of internal affairs investigations involving a couple Boston police who've been accused of heinous crimes, and Boston claimed a state law barred them from providing it. There have been a few other times when cities and towns have charged high fees or refused to provide records, and the Attorney General has also sent notes basically saying, provide these records or adjust your fees, or we will bring enforcement action, basically threatening to sue. And that has worked several times. but often the Attorney General has sided with agencies and decided not to sue. So they're definitely, I've worked with attorneys to bring over a half a dozen public records lawsuits, and that has been helpful.
Jennifer Cox is wondering, have you ever been able to obtain jail phone recordings for individuals who are not deceased?
I have not, but I have not tried.
Understood.
It is an excellent question. My understanding, it sounds like a number of agencies in Massachusetts will try to argue that those records are confidential. So you probably need a really good argument for why they should be made public. Maybe you need an example where something happened to the person in jail and those records will shine a light on it. Or maybe one possibility is maybe one party of the call will waive their right to privacy and give you permission and work with you to try to get records. It is super common in other states. It is less common in Massachusetts, but that doesn't mean that you can't get it. And it doesn't mean that a judge would find that the records are private, but it is an open question.
Christine McHugh is asking, have you ever heard of an agency or municipal department weaponizing public records requests and appeals? For example, a school committee publicly posting an appeal on the school website with the intent of retaliating against the requester and trying to chill First Amendment rights.
Well, there's certainly a lot of cases where public officials complain about public records. I had a town clerk complain that they were just complain about people swamping cities and towns with public records requests. And I said, oh, could you give me an example? And she had one request for, I think it was pet licenses, where somebody had made that request to lots of cities and towns. And I said, oh, how many of those requests have you gotten? Oh, it was just one, but they filed it with a lot of towns. Some people are sensitive. I don't think it is a problem if agencies advertise the fact that I've gotten public records. I've had people give me lots of tips because they found out that I was seeking records and they said, you know, I'm so glad you're interested in this town, or I'm so glad you're interested in this agency. Let me tell you about other things that are going on here. They're basically helping us advertise the fact that we're interested in doing real reporting and covering this agency. So I think it's fantastic. The other thing to note is if you file an appeal with the Secretary of State's office, that appeal is public. It is on the Secretary's website. Their decisions are on the Secretary of State's website. Not that many people look at it, but it is there.
Mm-hmm. And we have another question too, from Diane. She's stating that all her requests for local public records have been an exercise in futility. The individuals responsible for providing these records have flatly denied they existed, and I got no further despite reaching out to the AG. Perhaps I just gave up too quickly.
Got it. Well, it can be a problem if you ask for records and an agency says there are no records and you think there are, but you don't have any way to know for sure. One thing that I found is really helpful is looking at the records retention schedule for either the state or municipalities. It's online, you can Google it. And it lists common types of records that agencies are supposed to have and how long they keep them. So if they say they have no records and in the records retention schedule, it says they're supposed to hold on to them for 5 years, you can go back to them and say, it says right here by law, you need to hold on for these records for 5 years. What did you do with them? What happened to those records? And suddenly those records materialize. It's amazing. I've also looked on their own website for forms. And if they have a form, I know they're probably giving out that form and people are filling it out. I just want some evidence that they actually have those records. Sometimes there's a separate law that requires them to keep those records. Sometimes somebody sometimes they're mentioned in their annual reports or other documents or on their website. Sometimes it's just a matter of confusion. Maybe you're calling it one thing and they're calling it something else. So also just having a conversation with people. And if you can stop by the office and find somebody helpful and do it in person, that can be helpful too. Or just say, hey, I need some help. I know that I think there's some records, but I think I'm calling it the wrong thing. Can you work with me so I don't waste your time and am more specific and can help narrow it down? And sometimes agencies will want to help you so that you don't go back and forth a million times and you can just figure out what each other wants.
I'm glad you brought up the records retention schedule. It's great reading for anybody who's into requesting records, for sure. All right, we have another question. Are cities required to provide a reason as to why a request has been denied?
Yes, absolutely. Under the state public records law, there are a number of things that agencies have to do when they respond to public records. One of them is identify any records they are withholding and cite a specific reason why. And not only that, it's not just enough to cite an exemption like exemption C, which is privacy and personnel records and medical. They're also supposed to explain why that exemption is relevant, why it applies to the records you've gotten. So yes, they are indeed.
Diane, one of our previous questioners, she said that the records that she's seeking are emails and texts that are months old, and she knows they exist. Would you have any tips for her?
I think you can appeal, but you would need to show some evidence that they actually exist. A surprising number of agencies that should keep records don't keep records, or they keep them in a way that they can't actually find the records. Often a town clerk may not know the records exist. Sometimes they call things different things. Email can be hard to find. I've known people have deleted texts and don't retain them. Mayor Walsh, when he was Boston mayor, was famous for regularly deleting his texts. So when somebody would ask for texts, you can honestly say there were none. So there are some complications, but anything you can do that proves the records exist will help you get those records.
Hey, Todd, thank you so much for all this valuable information. Thank you for everybody who tuned in, and be sure to check out our other episodes on public records laws on NEFAC's website, nefac.org. And Todd, thank you again. We really appreciate it.
Thank you, and good to see you again.